Welcome, everyone, to the League of Women Voters of Portland General Meeting, our first of the 2013-14 program year. This year, the League is working with the financial partnership of the Multnomah Bar Foundation. The foundation has awarded us a grant to convert our general meeting content to education products for electronic and print media. We are very excited to get started. A number of foundation grantees are also with us tonight, as Margaret pointed out, and we are very excited to have them with us and look forward to collaborating and talking with them as we each go through our projects. Is that Mr. Talman back there? Is that Chuck Talman? Chuck Talman just walked in. He is a representative, one of our board liaisons from the Multnomah Bar Foundation, and he's also on the board of the American Constitution Society. So we're very happy to have this representation here with us tonight. As we have for the past several years, the League developed a theme for our year's work. Our theme this year is Government in Our Daily Lives, Foundations in Today. It expresses our interest in examining not only the public policy issues that demand our attention today, but their history. How and why are we concerned? How and why is the country concerned? Have we always been concerned? And how are we doing? Tonight, we begin, also as we have in recent years, with a discussion of the Constitution. We are looking at our foundation document through the lens of the general welfare, a term used in the Constitution but not defined. It is a term that the League, and I'm sure many of you, believe describes your interest in public policy. But is the Constitution fulfilling its promise to provide for the general welfare? Let's see. What did our founders have in mind? And how has the term evolved during our 200 years? Joining us tonight to help us learn and grow in our understanding are Professor Paula Abrams. Paula is the Jeffrey Bain Faculty Scholar and a Professor of Law at the Northwestern School of Law at Lewis and Clark College. Professor Abrams graduated with honors from the University of Michigan and received her JD from the University of California at Berkeley. Her primary research areas are in constitutional law, and her recent scholarship focus is on reproductive rights and population policy. Eric Legeson is with us tonight. She is an Assistant Attorney General for the Oregon Department of Justice. Ms. Legeson joined the Department of Justice in 1998 in the Trial Division Special Litigation Unit. She returned to the department in 2004 as an Assistant Attorney General in the Appellate Division. In the interim, she clerked for the Honorable Susan P. Graber of the U.S. Circuit Court of Appeals for the Ninth Circuit and practiced in the litigation section of the Stoll-Reeves law firm. Ms. Legeson handles civil, administrative, and criminal appeals before the Oregon Supreme Court and the Ninth Circuit Court of Appeals. Jerry Litz is the Assistant Attorney General for the City of Oregon. Mr. Litz has been Solicitor General in the Oregon Department of Justice. He has served in private practice, where he worked primarily for cities. Mr. Litz has served in the Department of Justice, specializing in higher education law, supervising civil appeals, and general counsel lawyers who advise natural resource agencies. He is currently a commissioner on the Land Conservation and Development Commission. Professor Abrams will lead us off tonight. She and the panelists have worked hard together to design and organize this very complex topic. They have their own plan, and it's an excellent one. So, Professor Abrams, will you begin and tell us what we're going to have tonight?
Thank you. I will. I want to thank the League for inviting us here tonight and giving us this opportunity to talk about a very important subject. Pardon? All right. How's that? Okay, so we have, it's gone. We have as our task to talk about the meaning of the General Welfare Clause, right, of the federal Constitution. The general welfare sounds like a topic that we could sit here for probably weeks and talk about, right? What does the general welfare mean? What responsibilities do the state and federal governments have? And we're going to talk a little bit about that tonight, but it actually, when we talk about the General Welfare Clause of the federal Constitution, we're actually talking about something much more specific than people may know. So what we are going to talk about tonight is we've just to kind of give you a brief overview of how we will proceed. I'm going to provide a general overview of the Welfare Clause and talk a little bit about the structure of the federal Constitution and its relationship to the states. And then Aaron will talk more specifically about powers of the federal government, and then Jerry will talk about the relationship between state and federal power. And then we're going to talk about a few topics that may be of some interest to you, like healthcare, the environment, education, and see how civil rights, and see how these issues actually play out in terms of an understanding of the general welfare. So who is responsible under our system of government for promoting the general welfare? Right? That's kind of the task, the question we have before us. And it's a complicated one. Article 1, Section 8 of the federal Constitution gives the federal government authority to provide for the general welfare. Okay? This sounds, as I said, like it could be a very broad grant of power to the federal government, but it actually has a very specific and perhaps more limited meaning. All right? When the framers set out to construct a government, they were interested in a government that divided power between federal and state sovereigns. And they were particularly interested, many of them were, in limiting federal government. They knew that the federal government had to be strengthened from the Articles of Confederation because it lacked the authority to tax or to regulate commerce in any meaningful way. But they were very concerned about a intrusive national power. And so the construct of the federal Constitution divides power between the federal and the state government. And it does so along these lines. The federal government under the Constitution is a government of limited and enumerated powers, right? And those powers are described in different places in the Constitution, but most of them are found in Article 1, Section 8. All right? And I'm going to talk about that in a minute. But the idea of a federal government of limited and enumerated powers is a very important one, because the concept is that if a power is not enumerated or explicit in the text of the federal Constitution, the federal government lacks the authority to regulate in that area, and that is an area that is reserved for state regulation, right? So when we talk about the idea in general of general welfare, I have my handy little Constitution, which I don't take everywhere, but I don't have to anymore. There's an app now, right? And there's a little federal constitutional app, and I've been carrying this around for a while, and my daughter loaded my app, and she said, you ought to have this on your phone. So I have a little app I can open up. But I wanted to just give you a little taste of this. This is where most of the powers of the federal government reside, in Article 1, Section 8. And I want you to listen just briefly to the kinds of things that are in here. To borrow money, to regulate commerce with foreign nations and among the several states, to establish a uniform rule of naturalization, to coin money, to provide for the punishment of counterfeiting, to promote and establish post offices and post roads, to promote the progress of science and the arts by essentially allowing for copyright protection, to constitute tribunals inferior to the Supreme Court, to define and punish piracies, to declare war, to provide and maintain a navy, to make rules for the government, to call forth the militia, and and to make all laws which shall be necessary and proper for carrying into effect. There are a couple other little things in there. I'm leaving out one very specific provision, which I'll get to in a minute, which is the General Welfare Clause. But you can see from this list, these are important powers, but they're very limited, right? They're not an overall power to make social policy on the part of the federal government. Now, here is the first provision of Article 1, Section 8. Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. Okay? That's the General Welfare Clause. So what does this reference to general welfare mean? Can the federal government, by virtue of this clause, do whatever it thinks is in the general welfare of the United States? Well, let's look again at what this particular clause modifies, right? Congress has the power to lay and collect taxes, to pay the debts, and provide for the common defense and general welfare, right? The General Welfare Clause of the federal Constitution is limited to the government's ability to tax and to spend for the general welfare, all right? Not just to make laws and regulate for the general welfare, but for the specific purpose of taxing and more particularly spending, all right? Now, that's not an inconsiderable power, but it is definitely a very particular kind of power, right? So if we think about taxing and spending, which is what the federal government can do for the general welfare, to the modern reader, the reader who we pick up the newspaper, right? It certainly may appear that the power to tax and spend is so broad as to amount to no limitation at all, right? Indeed, I think to some extent the contemporary view is that Congress's power to spend for the general welfare is a power to spend for virtually anything that Congress views as helpful. But it still requires spending. Right? It's not the power to just regulate in the interest of the general welfare. So if the activity that Congress is interested in is not on this list, right, of enumerated powers, then Congress lacks the power to regulate that activity directly. But what it cannot regulate directly, it may be able to impact through the spending clause, right? By spending money, right? Throwing money at programs and saying, you can have this money. But we start to think of, or lest we start to think of Congress as Santa Claus, which probably most of us would not be inclined to do anyway. Congress has the authority to distribute wealth, a great deal of wealth, but it can attach conditions to getting that money. So this gives Congress the power to use its spending authority to get results that it could not get through directly regulating, because it doesn't have the power. And let me give you a couple examples. For example, the federal government lacks the authority to regulate the drinking age in the states. There's no enumerated power that I read you that says that Congress has the authority to regulate the drinking ages. And this has been considered historically, even before the 21st Amendment, a state power, right? But here's what Congress can do. Congress can say to the states, we will give you money, right, to build and maintain your highways. But in order to get that money, you have to raise the drinking age to 21. Right? Now, the states are free to say, we don't want to raise the drinking age to 21. We thank you very much, but we won't take your money. How often do you think that happens? Not very often, right? Particularly in difficult economic times. Another example, right? Congress has, and this is one that we're going to talk about in more detail in a little bit, Congress has no authority to directly regulate education. That has been the prerogative of the states historically from way back. It's certainly not an enumerated power. But Congress, again, can offer the states money and say to the states, we will help fund your schools, we will help fund your education programs, but in order for you to get the money, you have to follow our policies on issue A or issue B, right? So that's the enormous authority that goes with the spending clause, right? The ability to spend money for whatever reason Congress decides is important to the general welfare. And the ability in the process of spending that money to add conditions for which the states have to comply in order to receive the funds. So with this kind of general view of the federal power, right, whatever is not enumerated is within the general welfare authority, so to speak, or what we call state police powers of the states, right? So when we think of the great wealth of criminal legislation, social policy, economic legislation, education, all health issues, a lot of these fall into the repository of traditional state powers, all right? And Jerry's going to talk about that a little bit in terms of how we divide up state and federal power in more detail. But for now, I'm going to turn it over to Aaron, who is going to talk about a very specific federal power that does give the federal government the authority to regulate directly for some areas that it may deem of general social policy interest. So, Erin, go ahead.
Thank you. Can you hear? Is this? To start off with, I should say I work for the Oregon Department of Justice, and anything that I say tonight is not the opinion of the state of Oregon or the Oregon Department of Justice. It's only me and what I've learned in my constitutional law class and by serving with the State Bar Constitutional Law Executive Committee with people like Paula and a lot from working with the Classroom Law Project's We the People program, which I think is probably my greatest source of ongoing knowledge about these issues, is having dialogues with the very bright high school students at Franklin High School, is where I work. So Paula says that Congress doesn't have the authority to regulate for the general welfare, that it has the power to spend money for the general welfare, but not regulate for the general welfare. And she may have been right about that at one point in time, but over the course of time, through, I think, craftiness by Congress and by a lot of change in the Supreme Court's view of a particular power of Congress, Congress has established quite a bit of power to regulate in promotion of the general welfare, although there still remain some limitations about that. But it's an area that's in flux and subject to ongoing debates almost every session in the Supreme Court term. And that power is the power to regulate commerce. In Article 1, Section 8, Clause 3, it's what's known as the Commerce Clause. And it says that Congress has this power. Congress can regulate commerce with foreign nations and among the several states, it's the keywords here, and with Indian tribes. And the power of regulating commerce among the several states is what Congress has managed with the assistance of the Supreme Court over time to turn into a tool to accomplish quite a bit. And after we do our general overview, we'll be talking in some more specifics about what Congress has been able to do with the Commerce Clause power. But what I want to do is just go over sort of the history of how the clause has been treated from at the outset to where we are now, and then we'll go on to Jerry. So under the Articles of Confederation, Paula mentioned, there was no power to regulate commerce among the several states, and that's just a problem. The states can be, they were sovereign entities of their own and could enact all sorts of regulations that might harm other states. So when we adopted our Constitution, we included the provision that allowed the federal government to regulate in the commerce among the several states. I think the early view of the provision in the constitutional law, Professor can correct me anytime I say something that makes her cringe, is that the point of the clause was to allow the federal government to prohibit discriminatory state legislation. And for example, if Oregon wanted to keep out wine from Washington and California, so our state legislature passed the law that said all out-of-state wine has to be sold for $25 among over the price. Well, that would obviously give in-state buyers the incentive to buy the cheaper, or more valuable, better deal Oregon wine, and would dissuade people from buying the out-of-state wine. And that's the kind of thing that's not good for the entire union. And so, originally, I believe the Commerce Clause was intended so Congress could step in and make the states be a little friendlier to each other with their regulation. That view of it didn't last for long. I think as the country became more industrialized, the court became, both Congress tried to regulate more of industry, and the court became more receptive to Congress's regulation of industry. And so beyond just saying that Congress can regulate and prohibit discriminatory state legislation, what the court said is that Congress can regulate activities that have a direct effect on interstate commerce, but not stuff that had indirect effects on interstate commerce. And this was around the late 1800s, I think, through around the 1930s. And it was this is an area that's interesting because the people on the court had, kind of weird views of how this would work. But they'd say, stuff that has a direct effect, like sales of goods in interstate commerce, transactions, maybe shipping, transportation of goods. That's the kind of stuff Congress can regulate. But the stuff that's taking place entirely in one state, like manufacturing, I think is one, mining, the stuff that was the start of the commerce process, that's the kind of thing Congress couldn't touch. So Congress may not have the power to set wage and hour laws for a factory that was in a state, but Congress could probably regulate things like shipping rates. That lasted till the early 40s, at which point the court said, and I think these are some of the words it used, that under the Commerce Clause power, Congress could pretty much regulate anything that affects interstate commerce enough to make it appropriate for Congress to regulate it. And so, appropriate's a really pretty broad word that gives Congress a lot of latitude because Congress can pretty much, if they're regulating something, they can probably figure out a reason that it's appropriate to regulate it in support of interstate commerce. And this was about the time there was a case that 2 years ago, I think in the Affordable Care Act case, you heard a case called Wickard tossed around a lot. And this was a case where Congress had decided to limit the amount of wheat that wheat farmers could grow on their land. And I think wheat farmers were going to be allowed to plant only 11 acres or 23 acres. And anyway, Wickard was going to plant his 11 acres, say it was 11, but he also had 23 acres that he wanted to plant for himself, and he wasn't going to sell that wheat to anybody. He was going to use that wheat only for his own consumption. He wasn't going to send it out of state or anything like that. And this case, he challenged the limitation of him planting wheat on only 11 acres, and as exceeding Congress's Commerce Clause authority because this wheat wasn't, in his view, going anywhere in commerce. Well, it goes to the Supreme Court, and the Supreme Court says, of course, this is okay because, you growing that wheat for yourself, that's going to affect the market because you might not be buying wheat from somebody else there. It has a relation. And if everybody in the country did this, the effects of this would add up. And, that would sabotage our goal in having these limitations on how much wheat can be grown. And so, that case is viewed, at least when I was in law school, as sort of the case that said Congress can do anything under the Commerce Clause to regulate for the general welfare. And later on, what the court came to say is basically under the Commerce Clause, Congress can regulate the channels of commerce, the instrumentalities of commerce, and any activities that substantially affect interstate commerce. It's like, what can't they regulate? Really, you're left with that question. And I think most people thought that there wasn't anything that they couldn't touch until the mid-90s. And then the court said, well, they remembered that this Constitution is what Professor Abrams said, and that it is a Constitution of limited powers. And they said, well, we can't regulate everything necessarily. So in 1995, there was a case involving a law passed by Congress that said you can't have guns near and around schools. And it was a federal criminal law, and I believe it was a pretty young man, maybe a high school student, who was charged with violating that law because he had a gun. And he challenged it and said, Congress, this is outside your Commerce Clause authority. This has nothing to do with commerce. And, the United States was in there defending the law. And I didn't reread their arguments, but I think they were arguing, it's a gun. The gun moved in interstate commerce. There's a connection to commerce. Of course we can do this. And the U.S. Supreme Court said, no, you can't do this. This is a crime. Schools are areas of traditional state control. This isn't about commerce. This isn't economic activity, just having a gun near a school. Therefore, this is something, Congress, you can't do in your enumerated power to regulate commerce. So in pursuing the general welfare, we now know that Congress can't prohibit guns near schools. Second case came up in 2000 and involved the Violence Against Women Act. And in that instance, Congress had passed a statute that allowed for people who were victims of violent attacks that were gender-based were allowed to bring basically a federal civil tort action for damages in the event they were harmed, even if the state opted not to bring any criminal charges. And that case, a woman was severely harmed, I believe sexually assaulted. It was based on her gender, and so she sued under the act for damages, and that goes to the Supreme Court and says, violence against women, this kind of thing, that's not economic activity. That has nothing to do with commerce. So no, this law is invalid. It's not something that you can accomplish under the Commerce Clause. And I think most recently we saw a limitation on what Congress can do under the Commerce Clause in the Affordable Care Act case in 2012. And even though the law ultimately was upheld as part of Congress's enumerated taxing power, 5 of the justices said that the Affordable Care Act required Americans, individuals, to purchase health insurance, and it penalized them if they would not purchase health insurance. And so the issue is that commerce? Is that a regulation of commerce? And 5 of the justices said, no, it's not part of Congress's Commerce Clause authority to make people buy stuff. If people enter the market on their own, once people choose to buy stuff and participate in the market, that's commerce. That's something Congress can talk about. But when people are sitting outside of the market and they don't want to buy stuff, Congress can't make them buy stuff because they're not engaged in commerce before they buy stuff. And so that's a very short history of the Commerce Clause from its beginning to where we are now. And a little bit later, I think we'll talk more about some of the specific areas where Congress has used the Commerce Clause power to regulate for the general welfare.
Can you hear me? So I will probably be a little less scholarly than my colleagues. Those of you who are expecting answers from me about what the law is probably will be disappointed, because my goal is to leave you with more questions. And lawyers know this, that the way you get at a legal issue sometimes is knowing what are the right questions to ask. And the law evolves, sometimes in strange ways. I think Aaron did a good job of describing some of the history of the Commerce Clause and how through the late 19th century and up through most of the 1930s, the court had a very narrow view of Congress's powers under the Commerce Clause. And then after President Roosevelt was able to change the composition of the court with his appointments, the court took a much broader view of what the Commerce Clause is. And Aaron, I think we'll talk about some of the cases from the 1960s, and then later we move back again, more constrained view of the powers that came in the 1990s and the early 2000s. And, you know, the way cases come up to the U.S. Supreme Court or to any court, there are two sides arguing different points of view. And one side will win and the court will explain its rationale. And they think that's great, but then the next case that comes along, the story is a little different, and it looks different, and the issue arises in a different way, and people say, well, wait a minute, that rule didn't really cover this case, so the rule gets modified a little bit. And this goes on, and you would think that after 20 or 30 cases, you know, the court would settle all the rules, but it doesn't work that way. If you pay attention to criminal law, search and seizure law has been going on for decades, and every year various courts, including our Court of Appeals, probably decides dozens of cases involving search and seizure law. Will they ever figure out what it is? And the answer is no, they won't, because every situation is all different, and the law works that way. It kind of moves a little this way, a little that way, and slowly it's kind of like plotting a curve on a graph with a lot of different points. At some point, the opinions sort of cluster around certain principles, and the court says, okay, now we understand the rule. And it sits still for a little while, and then something else comes up. So, the 10th Amendment. Most of us know about the Bill of Rights, and we think of the Bill of Rights as protecting personal freedom and individual liberty and protecting us from the government. The last item in the Bill of Rights, however, the 10th Amendment says, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So this is the principle that Paula started with, that the federal government has only those powers specifically granted in the Constitution, and the residue of the powers, the rest of it, sits with the states. And over time, the states' role has become probably less significant, certainly less significant than it was compared to the federal government's role, but the basic principle is still there. If the Constitution doesn't grant the power to the federal government, it resides with the states. So those of us who are state lawyers talk about the states having plenary power, or often the term is used, police power, which means not just public safety, but the power to govern in any way that isn't specifically prohibited by the Constitution or doesn't conflict with a valid federal law. So, personally, I grew up as a supporter of federal power. My parents grew up in the Depression era and then following in the New Deal era, and listening to them, I grew up thinking that the federal government was the way to address social problems. And then, as I came of age in the 60s, it was an era of federal civil rights protection and anti-poverty programs. And again, the federal government seemed like where the action is and where social progress is made. But then I went to law school in Oregon, and after law school, I went to work for the state first, and then later I went to work for local governments. So from a state lawyer's perspective, the federal agencies often seem rigid and bureaucratic and meddling. And as a state's lawyer, I also looked at local governments around the state, and I kind of thought they were amateurish and parochial, and I kind of thought of them, of the Lilliputians tying down the state government. And of course, I changed my mind about that when I started working for local governments and took on a city attorney role. And throughout both of those roles, as a state lawyer and as a city attorney, I have dealt with citizens and businesses, and often lawyers who represent businesses, who all perceive that government generally is intrusive and burdensome. And sometimes, I even agreed with them. So the point that I want to get across here is how you feel about government and what it does probably depends a lot on where you sit and what your perspective is. And as I talked about earlier, when law gets made in the court, you've got two sides. And when it works well, you've got two sides with different perspectives representing those different interests. And hopefully they kind of guide the court to some answer that works most of the time in a principled way for both sides. So maybe that's a long introduction to explaining why my perspective on the General Welfare Clause may be a little different than folks who rely on it in federal government and point to all the great things that the government has done. Now, I mentioned that the state has what we call plenary power or full power, whatever is not granted to the federal government. So where are those limitations on state power? I really give you three sources. I'm not sure that's an exclusive list, but one, specific provisions in the U.S. Constitution that give exclusive power to the federal government or restrict power, state power, or do both. Aaron is talking about the Commerce Clause, the federal government's power to regulate commerce. Sometime in the history of the Supreme Court's interpretation of the Commerce Clause, it developed the idea of the dormant Commerce Clause, which is that even where Congress has not exercised its power to regulate interstate commerce, the fact that it has that power means that the states can't do anything that would burden interstate commerce. So it's called the dormant Commerce Clause power because even where the federal government hasn't awakened or arisen to act, it still restricts the power of state government. I've been on the losing end of that issue a couple times. There are other things that are Paula mentioned that the federal power to issue currency. You can understand why in our nation we'd only have one currency, one national currency. Only the Congress can approve interstate compacts. The concept, I think, being that, states are not nations unto themselves and shouldn't be making treaties with other states, possibly to the detriment of yet other states. So there are those kinds of things in the Constitution that limit state power, and sometimes the federal government acts and says, we're within our power and states are not going to have the power. Then, in the Bill of Rights and in the 14th Amendment, there are constitutional protections for individuals. And those are extremely important limitations on state power. Free speech, freedom of assembly, the religion clauses that both guarantee the right to free exercise of religion and prevent the state from imposing religion, protections against unreasonable search and seizure, the guarantee of equal protection, due process protections for liberty and property. Those things are constitutional protections for the individual that the federal government guarantees citizens that the state can't deprive you of those protections guaranteed in the Bill of Rights. And finally, the third source of limitations on state power comes in what Paula mentioned, the strings that are attached to federal grants of money to the states. So when the example that Paula gave, a good one, when the federal government decides to fund construction of state highways, it can attach a provision that you don't get this money unless you agree, unless you provide that your minimum drinking age is 21. And in that case, basically, the states are agreeing as a condition of accepting the money. The states are agreeing to accept limitations on their own power. So again, those three things, the three limits on state power: powers that are granted to the by the Constitution to the federal government, the Bill of Rights and 14th Amendment protections for individuals, and then the state's agreement to the strings that are attached to the grant of federal money.
Before we go on, are we okay with sound? Can everybody hear? No? So we need everybody to speak up some more? Okay.
Okay, thanks. So if I can just kind of pick up where Jerry left off, and maybe we will go into a number of specific areas that we thought about raising to discuss in terms of allocation of state and federal power. If we kind of look at the broader concept of the general welfare, we're talking about divided authority between state and federal and sometimes local governments, right? And so if we think about the federal authority, we think about this broad interpretation of the Commerce Clause that Aaron talked about. Commerce Clause is the little enumerated power that turned into a monster, right? And basically has swallowed up many kind of social policy issues. One of the things that we're going to talk about is, and this is a good example of the federal government as a government of limited powers. Many of you may not know, but the Federal Civil Rights Acts are promulgated under the Commerce Clause because the Congress lacks authority to regulate for civil rights in and of itself affirmatively for private party behavior, right? What private discrimination. And so they use the Commerce Clause. And in the 60s, the court accepted that. I'm not sure they would today. But so we see a broad interpretation of federal power through the Commerce Clause exercise and broad use of the spending power, right? In reality, then, the federal and state powers and responsibilities overlap and interact, right? And this is something that you may hear discussed or referred to as cooperative federalism, right? That if we think about issues like healthcare, the environment, education, these are areas in which both the state and the federal governments have a role to play, right? Civil rights, both state and federal governments have a role to play. And interestingly, I mean, just kind of to respond to one of Jerry's comments about local government, one of the reasons that the federal government stepped in the civil rights area to pass the civil rights laws, stepped in the environmental area, right, is because of what was perceived by Congress as an absolute failure by the states to take on these issues and do something about them. Right? So the civil rights, and this isn't a generalization, but on some specific issues, why you see federal law or Congress asserting its authority is where, right or wrongly, there's a policy decision made at the federal level that some of the states have failed to enforce civil rights, right? Some of the states have failed to regulate pollution, And that was the consensus in the late 60s and early 70s that led to the passage of the federal environmental laws in air, water, waste disposal, and a variety of other environmental areas. So if we kind of think about dividing this authority, right, there's a role for both state and federal government to play. Sometimes the court has talked about cooperative federalism as taking a stick to the states, right? That either directly regulating them in some areas or in areas like the environment, like education, like healthcare, where the federal government has said, this is an area traditionally that is within complete state control, right? We'd like to respect that, but we think that there's some real problems going on that aren't being addressed, right? So let's have an arrangement where you do some things, we do some things, or we offer you the opportunity to pass environmental laws. And if you don't want to pass environmental laws, that's fine. We'll pass a federal law that runs a federal program in your state. Well, guess what happened with that, right? The federal government said in the environmental area, you have a choice. You can adopt a program in your own state that goes along with federal guidelines for protecting the environment and air, water, whatever the particular statute was. But you don't have to. We will pass a federal law, and we will run a federal program in your state if you choose not to. Well, guess what most of the states did, right? If you're a state, do you want to turn over the regulation of your environment to the federal government? So most of the states said, oh, okay, well, I guess we'll develop a federal environmental program. A state environmental program along federal guidelines, because that was preferable to the feds coming in and running a federal program themselves in the state in areas of very traditional state concern. So that's one example, and I'm sure each of you want to discuss some others that we can talk about.
Well, one area that I think is kind of close to home for us on the West Coast is the relationship of, I think, this federalist system and healthcare concepts. A couple of the high-profile cases about medical issues that have gone to the Supreme Court that have raised these issues of Congress's power have arisen from Oregon and California, and sort of illustrate how I think that they illustrate how important it is to think about really what are the limitations on Congress's power, and are there certain areas where it is better for the state to be able to make choices unencumbered by the federal choices, and is maybe that what the framers were thinking about? You'll hear tossed around a lot, I think, in the cases, the idea of the laboratory of the states was something that our Constitution was designed to preserve. And I think that's sort of what Jerry was talking about, is that the federal government has enumerated powers to do what it needs to do to keep the country together. But with these sort of broad social welfare areas, the states are a lot closer to the people and may be in the best situation to figure out what's best for those people. And recently, what we've seen a few years ago, California, like Oregon and many other Western states, have medical marijuana laws because the voters in many of the Western states have determined that marijuana actually can have legitimate medical uses, and want to be able to authorize the people living in our state and the other states to use that as a medicine. It's a policy choice about the value of this substance for medicine that these states have made. the federal government does not view marijuana in the same way. It's a scheduled substance on the Controlled Substances Act. And so this issue, of course, came to a head because the federal government says, marijuana has no legitimate medical purpose. California, the case arose out of California, says you can't say otherwise. And so that case went to the Supreme Court. Well, there's a case where, yet again, the Supreme Court said Commerce Clause is very broad. This was not an area where the Supreme Court decided to cut back. The Supreme Court says marijuana, there's a market for it. And that's a market that Congress, the federal government, has a legitimate interest in regulating because there's all sorts of bad things that can happen when marijuana is in the marketplace. And it's reasonable for Congress to say that states can't allow marijuana for medical use in their own borders, even if it's going to be kept entirely within the state borders, and even if the marijuana is never actually going to go into those other states that don't allow it, because it would just be too hard to manage. It would be too hard to achieve the federal objective if we were allowed that to happen. So the federal government currently does have the power under the Commerce Clause to override states' decisions to allow medical use of marijuana. Maybe that'll change. A lot of, as I talked about earlier, the view of the Commerce Clause has changed. I think sometimes it changes, perhaps with the court's view of the policy objective underlying the particular act. But again, this is an area where, as Jerry mentioned earlier, he grew up thinking the federal government was good. Well, maybe this is an area where it's better for the states to make the decision for the people. And the same issue was presented, although ultimately did not come to a head in the Supreme Court, in Oregon's Death with Dignity Act case, which, again, came out of Oregon. We have a law that allows people to die with physician assistance. And the federal government said they interpreted the Controlled Substances Act to say it's not okay to use any controlled substance to aid in dying. And the state of Oregon went to court just several years back and said, it's up to Oregon to decide how people should be able to end their lives. That's a medical decision. That's an area that's traditionally reserved to the states. Federal government, you do not have authority under your Commerce Clause authority to tell us what is good medicine. And so that went to the Supreme Court, and that federalism issue, the power of the federal government to override Oregon's choice, was underlying the case. Ultimately, the Supreme Court was able to duck it because it interpreted the Controlled Substances Act and said, John Ashcroft, who was then replaced by Alberto Gonzalez, no, Congress didn't actually say, Congress hasn't told the states that they can't use medicine that way. You're interpreting the statute wrong. We don't have to figure out whether Congress can override Oregon's decision. That would be, a hard issue. What we're going to say is they haven't overridden it. But again, my point is only this. These are areas where, if you're thinking as an organization of where you want to target your efforts to promote the general welfare, it's worth thinking about. Is this an issue that maybe the states or the local governments are better situated to address the needs of the people? Or is this an area where, we want the federal government to get involved and use their Commerce Clause authority or their Spending Clause authority to accomplish the goal?
If you have trouble hearing me in the back, please raise your hand. I don't have a lot of voice, but I'll try and talk as loud as I can. I agreed to talk a little about education as an area where there is this interesting dynamic between the state government and the federal government. There is not one word about education in the federal Constitution. There's a whole article about it, a short one, but there is an article in the Oregon Constitution, several sections worth, about education, and there's a thick collection of state laws that our state legislatures adopted, creating school districts or providing for the creation of school districts, talking about curriculum, teacher employment, teachers' rights, teacher certification and decertification processes, and all those things. So this is one of those areas where the state has full authority. And yet, in a minute, I'll review some of the ways in which the federal government has had just tremendous impact on education, and I think almost entirely for the better. Now, I mentioned earlier restrictions on state power and on local power through the Federal Bill of Rights. So in a long series of cases, the U.S. Supreme Court has, for example, stricken an Oregon law that required all children to attend public school. That was in 1925, after citizens of Oregon, I think heavily influenced by the Ku Klux Klan, basically tried to shut down Catholic schools in Oregon. In the 1940s, a decision that protected students' rights not to say the Pledge of Allegiance if it violated their religious beliefs. Probably the single most important Supreme Court decision of the last century, in my view, Brown versus Board of Education. School desegregation. I'm not sure I can think of any decision that has had such far-reaching impacts throughout our society. 1968, at the height of the Vietnam War, a case protecting students' right to wear a black armband in protest of the war. The Tinker case, and in fact, I noticed recently Mary Beth Tinker is on a 45th anniversary tour, explaining what that decision meant then and what it continues to mean today. We've had a whole slew of school prayer cases starting, I believe, in the late 1950s, early 1960s, right through the last several years. The court kind of goes back and forth. You can't mandate prayer, but you have to allow it. It's that balance between not endorsing a state religion and allowing students to practice their religion. There are cases on teachers' rights to due process before they're terminated, cases about searching students or their lockers, students' rights to have some kind of a hearing or at least a chance to meet with the school principal before being suspended from school. All of those decisions, and there's a whole pile more, those were all based on the Federal Bill of Rights or on the 14th Amendment. Congress had really nothing to do with any of those, but major influence on not only our school system, but really on our society. But Congress also has been heavily involved in education. And typically, these are through the congressional power, for the most part, has been not the Commerce Clause, but the Spending Clause. Congress offers money, states or school districts accept it, and with it, they need to administer a federal program. Those of you who wonder why the number of administrators in your school district continues to increase, the answer is the number of federal regulations continues to increase. So the power of the purse, and just a few of the statutes. Most or many of you, at least here, are old enough to remember Sputnik. One of Congress's early ventures into education was the National Defense Education Act of 1958. The Russians launched Sputnik, we were behind, boom, we need to boost science education. So again, Congress provided money, schools provided the programs. I'm not going to talk about the Civil Rights Act of 1964 because I think Aaron may do so yet, but I do want to touch on Title IX of 1972, which Any of you who follow women's sports probably are aware, and those of you who are anywhere close to my age remember going to school where girls' sports were, they weren't non-existent, but they were pretty close. It was field hockey, you know, and I remember that old expression, you know, you throw like a girl, because girls didn't play sports. They didn't throw balls very much, and they looked awkward. Not anymore. We've had Title IX now guaranteeing equal opportunities, or at least promoting equal opportunities for women in all educational programs. I think it's been most visible in athletics, but it's in all educational programs. I would venture to say this is not just in education, but in society generally. This has been a big part of social change in the last 40 years. There are also a whole series of acts in the 1990s banning discrimination based on disability. And again, major changes in how disabled people are integrated into society. That starts with mainstreaming kids in their classroom. So these things, when I think of them, particularly, you know, the Civil Rights Act banning race and sex discrimination in employment, Title IX, and the Disability Acts, these are congressional acts, but they kind of reflect the same kinds of values that you see in the federal Constitution, the prohibitions against discrimination. They're more affirmative, they're more wide or more specific in what they require, but they arise, I think, out of the same spirit. Then in 2001 or 2002, we get the No Child Left Behind Act. 800 pages of law. And I won't attempt to summarize all of the things or many of the things that it does, but it includes such things as telling public schools what, you know, when they need to inform parents that the school is not doing a good job of getting kids up to grade level in academic subjects, or when there have been too many crimes committed on the school campus. And it provides for a right for students to transfer if the schools are failing in some way. It requires tutoring services. It sets some standards for adequate yearly progress for students, which in turn has led to a strong focus on testing in many of our schools. And it has promoted charter schools. Again, these aren't direct regulations, but there's a lot of money behind it. So for most school districts, it's, if we want to eat, so to speak, we need to accept the money and we need to accept the conditions. So although technically Congress does not have the power to regulate education, it only has the power to grant money and attach conditions. In fact, I think in practice, this pretty much amounts to regulating education. And the question that I kind of want to leave you with, or a set of questions, is the No Child Left Behind Act a different kind of federal involvement in a traditional state function? To me, this is a different kind of federal program than ones that promote equal treatment or equal opportunity for girls and for people with disabilities. Honestly, I'm sure there's a good argument the other way, but I think there is, you see a qualitative difference. And I'll ask one more question or a set of questions. What if Congress decides that we ought to have a national curriculum? After all, we're a mobile society. It would be useful for students as they move around, or for people as they move around the country, to have a common basis of understanding that they can communicate about. So why don't we set minimum standards for a national curriculum. Interesting idea. Okay, so think about teaching literature to high school students. Should we teach the classics? Should we focus on the classics? It's good liberal tradition, isn't it? We'd focus on reading Plato and Euripides and whatever, Shakespeare. And well, that seems like a nice idea. In fact, I know there are several colleges around the country that are organized on that idea, the great books approach. But you know what? Almost all those people are old, dead white guys. So what if instead we suggested the national curriculum ought to include reading authors by with various backgrounds to present a different set of perspectives? So we'll have Latino authors, we'll have African authors, we'll have African American authors, we'll have immigrants, we'll have whatever. Is that better? I probably throw this out at this because I think of the League of Women Voters as a relatively traditional group, traditionally liberal group, and I think both of those are strong liberal positions. But you can't have them both if you're going to have a national curriculum. And to me, that's maybe one reason that we don't want to have a national curriculum, and we want to leave those choices to state and local governments.
Well, I'll pose a question to you. How is that possibly within Congress's enumerated powers to do that?
Because they're going to provide money to develop the curriculum.
But hasn't there recently been a theory embraced by the Supreme Court to suggest that they may not be able to do that?
Well, we'll see, won't we? I hope they don't. I hope the feds don't do it. But I'm, I asked it to be provocative. I'm happy to go argue the case in court.
And they're actually, just to follow up on that, one of the things that came out of the Affordable Care Act case was the idea that the spending clause authority is not unlimited. That actually, it's kind of, it's almost an addiction analysis where the court said, federal government, you're giving the states, so much money, and then you want them to change the policy in some other way, and you're threatening to yank all the funds back that you're giving them, that they're now completely dependent on, if they don't, say, take that extra step and adopt that national curriculum you're saying. And I think what a good number of the justices said in that case is, federal government, you don't have the power to completely pull the rug out from the states and take away all their funds if they decline to, adopt this new policy step. And that's a theory. It's called coercion theory because it's a very coercive practice. And just sort of I was familiar with it because I worked on a state case on behalf of the state of Oregon, where the state of Oregon sued the federal government, and we were trying to challenge some rules that the federal government placed on providing legal services to low-income Oregonians because we thought the restrictions interfered with our state's ability to regulate the practice of law. And we, of course, got tossed out of court pretty quickly on this coercion theory. There'd been one court in, I think, Virginia who actually discussed it in the context of education, saying, it just doesn't feel right that the federal government can get the states hooked on this money and then, basically use that to force the states to adopt whatever social policy the federal government wants. But a lot of people didn't think that theory had traction, again, until the Affordable Care Act case, which a number, I forget how many justices, but there were a couple who are considered liberal who even signed on to that doctrine. So I think, that may be an area where we see, as if you're thinking about your general welfare agenda, that it's important to keep in mind that maybe the federal government can't do everything with money that we once thought it could.
Well, the coercion limitation on the spending clause has been one that has really been the only limit that the court has been willing to entertain. And I think what Aaron is alluding to, they haven't really found coercion before in any case. But what Aaron is alluding to is that the court's beginning to think, well, maybe there are some limits on the spending clause. Maybe there's a point at which the federal government cannot extract certain dramatic conditions that would be very disruptive on the states. Historically, interesting, and I'm kind of wondering if some of the justices may actually go way back, because historically, Thomas Jefferson and James Madison argued that the spending clause only authorized the federal government to spend in relation to their enumerated powers. And Alexander Hamilton said, no, of course not. They can spend for anything they want. And his view prevailed and has prevailed historically. But, it may be that the court, as it is increasingly willing to see limits on the Commerce Clause after many decades of seeing almost no limits, is more inclined to maybe take another look at the spending clause. So I thought we wanted to leave a fair amount of time for questions. So, do you want to
just add one little thought, and that's that from the state's perspective, if the federal government is going to impose the requirements, it is nice when they provide money to implement.
Right. So we would be happy to entertain questions.
Questions will be coming up. Barbara and Kathleen will be taking your questions. I'd like to ask about the originalist view of the Constitution that's purported by several members of the Supreme Court. And it's very concerning to me if there's anything that has come from our conversation tonight, it's that the Constitution is a living, evolving, changing document. And what are your views on that? Is it a PR thing? Is it what's going on there? Is there an originalist perspective on the court, and there's a few that have described that way? What is it really? And do you see it becoming more pervasive? Are you concerned about it? What is it?
Okay, we could be here all night on that one. I'll take a shot at it first round. The originalist perspective on the Constitution is that and this usually comes up in the interpretation of rights, but not only in the interpretation of rights, but that's where I think that most of the controversy lies, that if a right or an interest is not clearly explicit or clearly implicit in the Constitution, then it is not protected and is subject to the political process. The originalists basically, there are a number of different schools of originalists, but the originalists basically say that the interpretation of the Constitution must lie within only the four corners of the document and the history of the framers. So what did they intend is one school. Justice Scalia is not real enamored of framers' intent, and he instead looks at what were the historical practices of the time. So the big case, the Heller case that was decided a few years ago on the Second Amendment, examined what were the laws at the time of the ratification of the Constitution as a way of understanding what the language in the Second Amendment meant. All right. So originalists on the court are a very strong force right now. I would say that on some issues, they may be a majority. On other issues, they're very close to one. And so, the the dead white men argument in terms of what is the Constitution. How do you interpret a document that was written in a time that is so different than our own? What the other argument is, the non-originalist argument, and I won't be giving away any secrets to say that I'm much more sympathetic to that position, is that the Constitution, as Anne suggests, is an evolving doctrine that is intended to interpret principles, right? And Justice Marshall said in a famous opinion, we must never forget it's a constitution we are expounding. It's not a specific list of regulations. It's a document of principles and values, right, and checks and balances. And so the non-originalists argue that the framers intended the Constitution to change, that they knew they couldn't see what the times would be like and what issues would come up 200 years from now, and they intended the meaning of some of these great phrases like speech and religion and liberty to change over time. Right, as our evolving standards changed in terms of what values we evidenced as a society. So it's a very, very real issue in constitutional interpretation.
Thank you very, very much, Paula. We have a question here on the Voting Rights Act, of great concern to our organization, clearly. Could you talk with us a little bit about the basis for the original law, the Commerce Clause or whatever, and the basis of the recent ruling?
Does anyone want to take that? Go ahead. Okay. Well, I'll just say very, very briefly about the Voting Rights Act. The Voting Rights Act was based both on the Commerce Authority, but also primarily on the courts or the Congress's authority under Section 5 of the 14th Amendment to enforce the Equal Protection Clause. All right, and so the Voting Rights Act was an outgrowth of enormous discrimination and disparities in access to voting throughout many places in the country, and so and that included lots of techniques like gerrymandering of district lines and literacy tests, a variety of a number of different things. And so Congress, this is one of those situations where Congress thought the states were doing a bad job, right? And so a number of states that were found to have constitutional violations under the Voting Rights Act in terms of access and non-discrimination requirements of the 14th Amendment were subject to particular jurisdiction of the federal government until those problems were resolved. So the change in the new law really takes away some of that oversight and requires evidence of more specific discrimination in order for the federal government to have any particular authority in the voting rights process in a number of different states. So the bottom line is that in many instances it will give the states more leeway to regulate and to be free from federal control, which may not be a bad thing, but it also gives them more leeway to discriminate, which is a bad thing.
Any other comments on Voting Rights Act?
I can be corrected, but I believe, oops. Wasn't part of the basis for the decision that it offended sort of the sovereign dignity of the state? It was a very odd decision that announced this new concept where I can't remember the phrase, but it was something about it offends the sovereign dignity or equal sovereignty principle. It announced a new principle that, as far as I can tell, no one had ever heard of before. I don't know, it may be located somewhere in the 10th Amendment or somewhere else, but it'll be interesting to see where that goes, and maybe someday find out where that came from.
That would be nice.
Other part of the Supreme Court's decision that I found interesting was that the majority and the minority on the court obviously read the record very differently. Justice Roberts wrote, basically, this law is 40-some years old at this point and is imposing restrictions that are based on the kinds of discrimination that were going on in the 1960s, and there's no evidence that we continue to need this kind of regulation. And in her dissent, Justice Kagan said, what do you mean? There's no evidence that we don't continue to need this kind of regulation. Here are all the pieces of information, and she listed only some of them, that Congress had in front of it when it decided in 2007, I believe, to renew the Voting Rights Act. So there was an almost of a factual issue of, is this still necessary? And Justice Roberts, with his theory about how, about state sovereignty, clearly had a bias of, unless it's absolutely proven we don't need, that we still need it, then we should overturn the law. And Justice Kagan basically saying, this is the kind of decision that's up to Congress under its power to enforce the 14th Amendment, and it had a strong record that we still need it.
Here's a nice local question. Here's a nice local question for us. The city of Portland must cover their open water reservoirs. They appeal to the federal government. Can you explain what stick the feds used, since this does not affect other states?
I'm from Eugene. I don't know.
I'm not exactly certain what the governing issues were on that. I assume that, and I could certainly be wrong, that this has to do with federal environmental laws in terms of and national security. As I recall, there was a concern about access to open reservoir based on national security issues, about tainting the water supply. And if it's a national security issue, the local government's going to lose.
There also is a federal Safe Drinking Water Act, but I don't know if that was at play in this decision.
Do you know if that's spending clause legislation or commerce clause legislation? I mean, things like that often tend to be the money base, but I don't know whether that was the basis here.
Do you all believe that the Affordable Care Act is in jeopardy? I mean, I'm sure are there cases in the pipeline to still challenge the constitutionality of the act?
Yes. Every which way, politically, legally, that can be attacked. There are different pieces of it that are being attacked. I think the court has spoken on the main operative mechanism. And I think that that's a done issue, but there are lots of peripheral issues too.
This will conclude, thank you very much, Professor Abrams. This will conclude our taped portion of our event tonight. It's been invaluable. It has helped us expand and broaden our understandings of the Constitution and will greatly inform our work going forward. We thank all of you very much, and good evening.